Good afternoon, and welcome to McGuireWoods SEC Compliance and Disclosure Update discussing ransomware attacks at public companies. I am Stephanie Briggs-Evans, a partner in the firm's Securities and Capital Markets Department and the moderator for today's program. McGuireWoods is a full-service law firm with more than 1,100 attorneys in 21 worldwide offices. Our more than 50 securities and capital markets lawyers represent some of the nation's largest businesses and financial institutions in complex securities and capital markets matters. We rank among the top law firms for debt and equity issuances based on deal volume and dollar value in reputable benchmarking league tables published by Refinitiv and Bloomberg, and have earned repeated honors from the International Financial Law Review, including for Debt and Equity Linked Deal of the Year. Before we begin today's program, I would like to call your attention to the Q&A icon in the lower right-hand corner of your screen. Please use this widget to submit any questions you may have for our panelists at any time during the program. We will do our best to address your questions in the time allotted. However, if we are unable to do so, we will follow up with you by email. You will find a number of additional resources along the right side of your screen, which we encourage you to explore during the presentation. Notably, the Meeting Materials folder includes a copy of today's presentation slides. Without further ado, allow me to introduce our first speaker, Janet Payton. As a partner based in our Richmond office, Janet practices in the areas of intellectual property and data privacy and security. Janet provides worldwide brand protection, enforcement, licensing, and transactional IP services, and she assists clients with preventative data security as well as compliance issues in the aftermath of a data breach. Janet?
Thank you, Stephanie. I appreciate that intro. So my role here is to set the stage. My colleagues will talk with you about how the data breach incident can have significant impact with respect to the SEC and your obligations as a public company. My role is really to just describe to you what it's like to have a major data breach occur. So at the beginning of a data breach, it's often the case that it's a little bit chaotic. You're not exactly sure what's happened yet. It is in the way of any emerging emergency where information is coming to you from lots of sources and everyone is sort of rushing around and calling each other and trying to figure out what's going on. It will be chaotic, but one of the ways to manage that and protect as much as you can against it is just to plan up front, have an incident response plan, and have an incident response team who has practiced what to do. It is so much easier to address this when you can pull out that plan and say, step 1, step 2, step 3. So I encourage you to think about that as we go forward. But the first thing that happens in a ransomware breach is that everything gets locked up. So in fact, compared to a lot of other kinds of data breaches, it's generally pretty obvious, fairly quickly, that you have had a data breach, because in a ransomware attack, you can't access your system, you can't access your network. Often your computer screen shows a message that indicates that it has been locked as the result of ransomware and gives you directions about how to get to a ransom note. Often the ransom note itself is held on the dark web and you're given a code to get access to that, and that ends up being the method for communication if you decide to communicate with the threat actors. But just as far as those first few minutes where you're trying to figure out if you've had a breach or not, that's the only time that ransomware is easier than other kinds of breaches, because it's usually quite obvious that you've had it. The other things that can happen, though, that you should be alert to, because these also suggest that a breach is occurring, are things like your IT report. You know, your IT folks are letting you know that they're seeing something unusual happening on your network. They're seeing a large amount of data going out the door. Anything like that that is unusual ought to trip somebody paying attention to the data incident response plan and thinking about whether or not this might be related to a data breach. It's also the case that we're seeing lots of wire fraud right now, and many times because in a wire fraud situation, you're focused on the money. You're focused on the fact that someone in accounting got a fake invoice and believed it and paid it, or got new wire instructions from a very familiar counterparty and didn't recognize that they should double check by phone with a person they know before ever changing wire instructions. So often in a wire fraud situation, the money is out the door and everyone is focused on the money and not thinking about the fact that your system must have been infiltrated. Usually your email has been infiltrated for the perpetrators of that wire fraud to learn who has access to what kinds of accounts and to learn what an email that you might be expecting would look like so that they can do a great job of faking that email and getting you to change those wire instructions and so on. So always remember that in a case of wire fraud, there is almost certainly an email breach associated with it. And if the email accounts that were breached have confidential information in them, documents attached, and so on, then it's the same as if, you know, any other aspect of your network was breached. And then the one that probably we're all most familiar with, just something got lost. Somebody left their laptop on a plane and the laptop wasn't encrypted. Somebody left paper files somewhere. In those cases, you always have to evaluate whether or not it's actually a reportable data breach, depending on the content of those materials. But as we said, today we're talking about ransomware. And the next few slides I'm going to walk through could be ordered in any order, because all of these things really have to happen at the same time. These are the key questions and issues that you'll want to think about when you're managing those first few hours of a data breach. Very, very critical basic question is what kind of data was involved. And the two kinds that you're most concerned about are personal information of individual people and trade secrets. If either of those things were potentially exposed, that's where there could be some really serious ramifications and some absolutely mandatory notifications to both regulators and individuals. If you've had a ransomware attack, every system that is locked is potentially infected and has potentially already been the target of exfiltration. So if it spreads quickly through the organization, the scope of that obviously can be very, very large. The kinds of information that we're really interested in beyond trade secrets, which are always critical, are personal information that would trip an obligation to notify the party and potentially state attorneys general, federal regulators, other folks. So the kinds of information that will always trip those notifications unless they were encrypted and the encryption keys were not available to the hacker are things like your name with a social security number or credit card information or other financial account information. But many people make the mistake of thinking that these are the only things that would trip a notification obligation. And that's just not the case. We have a really complex system right now of 50 different state laws and then federal regulation of different industries that's overlaid on top of that. So when you go through this list of different kinds of information, name and email is perhaps the only combination that if that's all that was accessed, you probably don't have a reportable data breach. There are some states that treat name and email as PII for regulatory purposes, but even those states don't require breach notification if that's all that was breached. But what if there's just one more element, name, email, and password? lots of states would be tripped by this or by a username and password being accessed. What about a name and a date of birth? Many people think this is not sensitive information. In fact, the vast majority of people have their dates of birth on Facebook. But there are 2 states, North Dakota and Washington State, that say if you have a breach that involves name and date of birth, that is a reportable breach. Medical information. Again, it's often the case that folks think if we are not subject to HIPAA, then we don't have a reportable breach where personal medical information was involved. That's not true. There are a number of state statutes that implicate medical information and require notification to the people that were affected and to the Attorney General. And the question that you always want to ask in this situation, no matter what the circumstances are, is was the data encrypted? If it was encrypted, and if the encryption keys were not available to the threat actor, you are golden. Encryption is the best solution to protecting yourself from that kind of liability, because if it was encrypted and the hacker could not unencrypt it, then it's not a breach. Okay, so let's also talk about where do we turn to figure out what laws are going to govern our actions when we've had a data breach. It is an absolute patchwork right now of laws. There are several bills pending in Congress that would at least purport to advance a federal data privacy bill, including notification requirements that they intend to preempt state law. There are also states like California that have said, we will not be preempted. We will ensure that we are never preempted. So we're right in the middle of a very complicated time where there are lots of different statutes that might apply, and sometimes they preempt each other, and sometimes they don't. So with respect to federal law, we don't have a federal data breach notification law right now. We only have federal laws that apply in specific industries. So if you are a medical services provider or you are a business associate of a medical services provider, and in either case are therefore subject to HIPAA, HIPAA has data breach notification requirements. Some states say if you comply with HIPAA, you can ignore our state notification law. Others say not. Others say you will comply with our law as well as HIPAA. If you are a bank or any kind of financial institution that's subject to Gramm-Leach-Bliley, Gramm-Leach-Bliley also has specific data breach notification requirements. And again, like HIPAA, some states say comply with Gramm-Leach-Bliley and we don't need you to do anything else. Others say we want you to comply with our law as well. So it's important to know what regulatory scheme affects you and what covers you. And if none, if you're not a bank and you're not a healthcare provider, you're a manufacturing company or something, there are still other laws that might apply beyond state law, for example, international law. We've all heard about GDPR, and GDPR has a very long arm. Canadian law also applies if you have the data of any Canadian people. And then state law, governed by the state of residence of the individuals whose information was breached. Again, many folks get confused about that. Your contracts may have obligations in them, so that's another source of potential obligation to notify someone. Industry standards, for example, if you accept credit cards, you're subject to the payment card industry standards, and they have notification requirements. And then, of course, the main thing we're here to talk about, disclosure of the incident publicly as the result of being regulated by the SEC. So quickly, a list of things to do in that first hour. Call your insurer and call outside counsel. It's important to do both of those things very quickly as you assemble your incident response team, because you're going to want your outside counsel to engage your forensic investigator. The reason for that is the hope of privilege for the reports that they generate. If you engage your forensic investigator and counsel is not involved, those reports for sure will not be privileged. Now, the privilege is fragile, and you may not be able to keep it. It may be that it's not privileged even if counsel does engage them, but that really is the only hope of it. So we strongly encourage that. And in a ransomware scenario, ask your team, can we stand our system back up from our backups? Are we going to be able to possibly stand it back up without having to pay ransom, without having to, trust the hackers to unlock it? Is it possible to do? Obviously, that's always your goal. What is the likely timeline of that? That's going to factor into your ransomware and potential payment or non-payment of ransom decision. And does the company already have a stated policy on the payment of ransom? Because if you have one, you certainly want to take that into account. Managing communications to employees, customers, and the press is something that will be pressing in the very first hour and something to have in your plan ahead of time. And last but not least, timing issues. Your contracts will often have a very short notification obligation. If you have a breach, you have to notify the contract party within 24 or 72 hours. State requirements for notification to individuals. There is a list here for you in the materials, lots of different ones for different states. The shortest is Vermont with an AG notice after 14 days and Puerto Rico with a 10-day notice to data subjects. Now, I will tell you, I've never seen Puerto Rico react to late notices ever. That's just a pro tip, but they do have a very short deadline. And then HIPAA and GLBA have a 60-day notice. So all of these different deadlines are important. And some of the AG notices are due before the notices to the individuals are sent. So if you're subject to state law, that's another timing issue. And in a credit card breach, you have to notify the brands very quickly. Typically notify your own merchant bank right away, first 24 hours, and they will help you with the notifications to Visa, American Express, and so on. So that's a really quick blow through. As I said, all of those things in any order and all at one time as the breach unfolds itself. So now I'm going to turn it over to Barlow to talk about the SEC.
Thank you, Janet, for setting the stage. Our next presenter is Barlow Mann. Barlow is a securities and capital markets partner in our Charlotte office. Barlow focuses his practice on representing public and private companies in securities transactions and other general corporate matters. He advises companies in connection with a broad range of securities matters, representing both issuers and underwriters in initial public offerings, secondary offerings of debt, equity, derivative, and hybrid securities. He will discuss the SEC reporting considerations to take into account during a ransomware attack. Barlow?
Thank you very much, Stephanie, and thank you for setting the stage, Janet. So obviously, if you are a public company that is subject to a ransomware attack, one of the very first things that you will be thinking about is your disclosure obligations under SEC rules and stock exchange requirements. That includes, Form 10K and 10Q, as well as Form 8K and the NYSE or Nasdaq prompt disclosure rules. Janet is certainly correct. We have had many inquiries from our public company clients over the past couple of months who have been in the process of putting together incident response plans or playbooks that they want to have on the shelf in case they are targeted. And in many cases, a chapter in that playbook is, what do we do about our reporting obligations? What might our disclosure look like, and things like that. So I'll step through some of those considerations now. I guess the more kind of pressing requirements to consider in connection with an attack are the Form 8K or the stock exchange considerations. And as with so many SEC disclosure questions, the key factor to consider in connection with a ransomware attack is whether or not the attack is material. The SEC in 2018 issued a cybersecurity release which provides some helpful guidance on this topic. And I've included two quotations from that guidance on the slide here. The first bullet, in the first bullet, the SEC focuses on the nature, extent, and potential magnitude of a cybersecurity incident, particularly as they relate to compromised information or the business. So this is kind of an inward-looking consideration. What's the extent of the attack, of the damage within the company? The second quote focuses on the range of potential harm, and a lot of the factors the SEC discusses here are more outward-looking. For example, what about the company's reputation? A cybersecurity incident, even if it's relatively minor, might have much more significant implications for a data security company than for a widget manufacturer. So, that's the type of thing you have to consider, as well as, any other downstream effects, for example, on customer and vendor relationships, potential litigation, or any regulatory activity. And one other significant factor to consider that was not mentioned necessarily directly in the 2018 release is the direct financial impact of the ransomware attack, including any ransom paid, the loss of revenue of income, or other costs associated with the attack. And in fact, the question of whether or not to pay the ransom itself is an important one that we will touch on in a later presentation. The OFAC in the U.S. and some other agencies have issued guidance recently around, the circumstances under which it can even be appropriate to pay a ransom. Okay, so let's assume that you've determined that the ransomware attack is indeed material. What do you do next? What are the disclosure requirements? Form 8K itself does not have a particular item that calls for disclosure of ransomware attacks or other cybersecurity incidents. However, there are a few things that companies that have been targeted should consider. First, the SEC's 2018 guidance encourages prompt disclosure of material cybersecurity events on Form 8K or Form 6K for foreign private issuers. So even though it's not a technical requirement of Form 8K, the SEC certainly encourages this disclosure. If a company has an active shelf registration statement, or if it's currently marketing a private deal, it will need to consider the need to include disclosure about a material ransomware attack in its shelf registration statement or its prospectus for a deal. And another thing to keep in mind is that the SEC has noted that disclosure on Form 8K reduces the risk of potential selective disclosure, i.e. Regulation FD and insider trading issues. And these could be intentional, accidental, or even simply just perceived Reg FD or insider trading issues. So it may very well be that an executive officer is trading stock, and that particular officer isn't aware of the ransomware attack, or a trade accidentally happens while an executive is aware of the incident. And all those types of activities will be viewed in hindsight, 2020 hindsight. So if there has been a material attack, the more quickly you can get appropriate disclosure out there, you can mitigate some of these issues. In addition, the other consideration highlighted here are the New York Stock Exchange and Nasdaq prompt release requirements. Both the New York Stock Exchange and Nasdaq have policies that require listed companies to promptly disclose material information in accordance with Reg FD compliant methods. So even though there's not a specific 8K disclosure requirement, your stock exchange listing rules likely would require public disclosure via a Reg FD compliant method if you've suffered a material ransomware attack. Okay, so what about a non-material ransomware attack? If you've determined that the attack is not material, then the SEC and stock exchange considerations I just noted will not be present. However, if the non-material attack is likely to become public anyway, there may be certain advantages to filing a Form 8K, as well as certain disadvantages. And I've summarized certain of those on the next slide. a non-material attack might become public for any number of reasons, including required disclosures under laws relating to PII, as Janet was just discussing, leaks from within the company or from third parties, such as customers or suppliers who might become aware of the attack, or discovery by a governmental or regulatory agency. And then if you do decide not to file an 8K because a ransomware attack is not material and any other factors weigh against filing an 8K and disclosing it, you may need to revisit whether disclosure should be included in later Exchange Act filings, such as your Form 10K or your Form 10Q. Again, even if the attack is deemed not material, and I'll go into greater detail about that in just a few minutes. Okay, so this slide summarizes some of the potential advantages or disadvantages of filing a Form 8K for a non-material ransomware attack. In the potential advantages column, you could potentially cut off any potential claims that insiders traded on MNPI or that the company violated Regulation FD. Now, you might say, you might think, if we've determined the attack is not material, how could insider trading or Reg FD be a problem? This goes back to the point I made a moment ago about appearances. Even if you were confident in your conclusion that the attack was not material, if insiders were trading and the attack was being disclosed selectively to certain people, and then the fact of the attack becomes public later on, all of those facts will be viewed in 20/20 hindsight. You might also avoid SEC comments. It's not uncommon for the SEC to ask companies to disclose cyber attacks, even when the company makes strong arguments that the attacks are not material. And finally, getting out in front of the problem and filing an 8K and making public disclosure allows you to control the narrative around the attack. That being said, in the second column, there are potential disadvantages. You may incur unnecessary reputational harm or draw unwarranted attention by filing an 8K. You might make the incident seem worse or more significant than it was, which could affect the stock price, even if the attack was not, in fact, material. And making public disclosure might also attract further attention from cyber criminals because they may figure that if you were subject to one attack, you could be an easy target. Okay, so if you've decided to file an 8K, either because the attack was material or otherwise, what would the content be? Because Form 8K does not have a specific item relating to cyber attacks, companies generally report such events under Item 801, which is a practice endorsed by the SEC in its 2018 guidance. A survey of 10 recent ransomware Form 8Ks shows that they often disclose the following things: that the attack has occurred and the date the company became aware of the attack, the systems affected by the attack, actions that the company has taken in response to the attack, for example, engaging cyber defense professionals, cooperating with law enforcement, implementing additional security measures, working on system recovery, among other actions. Whether any personally identifiable information may have been compromised as part of the attack, as well as a general description of the expected impacts on the company's operations or financial results. And one item that's not listed here, but we also see sometimes, is whether the company anticipates to receive any insurance proceeds to help offset the effects of the attack. Each one of these Form 8Ks is unique, and it would be very important to consult with internal and external counsel, consider potential precedents, and really take into account the unique circumstances of your own ransomware attack when thinking about your disclosure. But the list on this slide is a pretty good list, I think a representative list of the types of things that companies are disclosing when they've been subject to a ransomware attack. To provide a little bit more color about what these 8Ks are looking like, 5 out of the 10 companies we reviewed indicated that They did not expect the incident to have a material effect on the company's business operations or financial results, or a similar statement to that effect. So there are, in fact, many companies out here filing Form 8Ks for non-material ransomware attacks. On the other hand, another 5 out of the 10 companies we reviewed indicated that it was too early to determine what impact the attack would have. Or they may say that the attack interrupted the company's business and could adversely affect revenues, costs, etc. And in fact, some companies are filing amendments to their original 8K once they are able to gather more information and provide more concrete information about the attack and the potential impacts on the business. The ransomware 8Ks that we reviewed generally did not include specific disclosures relating to ransom amounts paid or other expected costs. And then one other point to keep in mind here is if the ransomware attack is deemed to be material, you should really consider what details need to be included in the Form 8K in order to protect against potential selective disclosure or insider trading issues. If the attack is material, you would hate to file an 8K but leave out important information. That means you've taken potential reputational harm by disclosing the ransomware attack, but if you've withheld material information about that attack, then you still potentially have insider trading issues, Regulation FD issues, or if you're engaged in a securities offering, Section 11 or 10b-5 issues. So if the attack is material and you're filing an 8K, it's important to have a thorough consultative process with internal and external counsel to make sure the disclosure is appropriate and includes all the material facts. Okay, so to bring the consideration of disclosure issues back around to the Form 10K and 10Q. Similar to the Form 8K, no existing disclosure requirement applicable to 10Q or 10K expressly requires disclosure of cyber incidents. But the SEC has repeatedly stated that a number of disclosure requirements may impose an obligation to disclose such risks and incidents. In particular, the SEC has emphasized risk factors, MD&A, business description, legal proceedings, and financial statements. Cybersecurity risk factors have become more and more common over the past couple of years, and it's becoming important to take a fresh look at those each and every year. The SEC actively comments on these and asks questions about them, so that is a very hot area. In particular, regarding risk factors, the SEC has stated that if a company has experienced a material cybersecurity incident, it would not be sufficient for the company to disclose that there's a risk that cybersecurity incidents might occur, or that there's the potential that the company could suffer such attacks. In that context, the company should discuss the actual incident and its consequences as part of a broader discussion about potential cybersecurity risks. And in fact, there have been some recent enforcement actions in this area where companies continue to include semi-boilerplate or generic disclosures about potential cybersecurity risks when in fact they had been targeted and suffered specific incidents. We will touch in a little bit greater detail on those enforcement actions later on today. In addition, in comment letters, the SEC has frequently urged companies to disclose past cybersecurity incidents that are not material, even when the company presents strong arguments against such disclosure. So even if a company chooses not to file a Form 8K at the time it suffers a ransomware attack, the company will likely need to analyze that potential disclosure again in connection with its next 10Q or 10K filing, and may receive an SEC comment if it elects not to disclose the attack. That's the end of my slides. I hope that I've been able to provide a helpful overview of potential disclosure issues. We really are seeing more and more inquiries of companies trying to plan in advance their response to these potential attacks, and especially with the increasing role that the SEC wants boards of directors to take in cybersecurity risk oversight. It's becoming very important for companies to focus on this and plan with their internal and external counsel to ensure that they have adequate and appropriate plans in place. So thank you very much for your time today, and I'll turn it back over to Stephanie to introduce the next presenter.
Thank you, Barlow. Our next presenter is Alex Brackett. Alex is a government investigations and white-collar litigation partner in our Richmond office, where he is also co-head of the McGuireWoods Strategic Risk and Compliance team. His practice focuses primarily on advising and supporting corporate and individual clients in the areas of white-collar criminal defense and internal investigations. He will discuss whether to pay or not pay in the event of a ransomware attack. Alex?
Great, thank you. Yeah, in my section, we're going to move relatively quickly through several different considerations that a company needs to think through when deciding whether they are going to pay a ransom in order to try and get through a ransomware attack or not. First, a few threshold questions, some key ransomware payment questions that everybody needs to ask. Is it legal? Is it advisable? And do I have the technical ability to pay? From a legality perspective, the primary risk in making a ransomware payment is that you could be paying a bad actor who is subject to some form of U.S. sanctions. The sanctions we'd be thinking about here would typically be those administered by the Office of Foreign Assets Controls, or OFAC. And in the last year or so, OFAC and other government enforcement agencies have been increasingly vocal about raising this concern and indicating that they want companies to take this very seriously and be cautious in making the decision to make a payment and to ensure that they're screening thoroughly to make sure that if they do make a payment, there's no indications that it's to a bad actor. And that's part of a broader government scrutiny at the federal level and to some extent at the state level. The U.S. government has a policy of strongly discouraging ransomware payments because of the potential to fund geopolitical adversaries, global terrorists, and others who are acting against U.S. interests. And this has actually been declared a national security threat at the federal level. Moving to the question of whether it's advisable, this is always a risk that a company is going to take. There's no guarantee that the criminal counterparty you're dealing with is going to follow through on what they've said they're going to do once you pay them. At the same time, the cyber criminals who are operating in this space are operating in an increasingly sophisticated way and in a very transactional and in some respects corporate way. To many of them, it is a business, and it's a business that is ultimately grounded on credibility. And the only way that people are going to continue to make ransomware payments is if they actually do make good on what they've said they will in terms of releasing data in the event you make the requested payment. And there's just a practical aspect for a business that is caught unprepared by a ransomware attack, particularly if it's a smaller or less sophisticated business, the ability to survive without paying the ransom and freeing up their data and systems can be quite daunting. And so for some organizations, they just feel that there's really no path forward other than to make a payment. Which leads us to the final of these initial questions: do I have the technical ability to pay? Not surprisingly, if you go out to your bank or other financial institution, they are going to be very loath to assist you in making a ransomware payment. It is not something that is within their risk tolerance. A number of cybersecurity firms in particular have stepped in to fill this void, and they have been offering a variety of crypto ransom payment services. In some respects, that includes some tools that will help companies that are going to make a payment to screen and do their best to ensure that the person that they're paying is not for example, a sanctioned party. They're doing this in part as a service to assist the company that's making the ransomware payment, and also because those companies are very much under scrutiny right now by the federal government. Because were they to pay a sanctioned party, they could be held accountable for facilitating a sanctions violation. And this is a critical consideration too. One, a lot of people just aren't going to have the fluency to be able to go out and acquire Bitcoin and pay it into a crypto wallet. And a lot of the crypto exchanges that are out there are geographically ring-fenced and have risk-based transaction controls themselves. So if you do find yourself in the unfortunate situation of needing to make one of these payments, there are sophisticated parties out there that can assist. Just a quick timeline on some of primarily the federal government's oversight and involvement in this space. In October of last year, both OFAC and FinCEN issued advisories about risks relating to ransomware payments. The upshot of these notices were largely to flag the potential for a ransomware payment to result in a sanctions violation as an issue to be considered, and some related risks of potential inadvertent sanctions violations. In April of this year, the DOJ formed a ransomware and digital extortion task force and declared ransomware a national security threat. And in June, following the Colonial Pipeline ransomware attack, the DOJ actually managed to seize and recover most of the ransomware payment that was made to free up the Colonial Pipeline, amounting to about $2.3 million. And the DOJ at the same time issued some guidance regarding ransomware investigations that was largely about coordination within the DOJ and with other agencies. Interestingly, just in the last week, OFAC has issued an updated version of its ransomware guidance and imposed sanctions on a crypto exchange called SUEX OTC, which it asserts has been facilitating the cash out of ransomware payments by criminal organizations. This designation of SUEX is pretty significant. It's something that OFAC has been signaling in recent weeks that it was inclined to do. It's an effort to cut off a key link connecting the cyber criminals to the ability to actually monetize these ransomware payments. There is technical ability to do some level of tracing of ransomware payments through the blockchain, and for the criminals to be able to successfully get their hands on and cash out these ransomware payments, that they typically need some kind of actor like SUEX to be a point in the chain where there can be some obfuscation and where there can be some movement of the cryptocurrency that allows them to free it up. OFAC has asserted that about 40% of SUEX's transactions were associated with illicit actors of one stripe or another. In terms of the new guidance from OFAC, it's a significant expansion of the details that were in the October 2020 guidance. It goes into a lot more detail discussing the history of OFAC enforcement in this space, but importantly, it provided a good level of detail in terms of guidance for mitigating potential enforcement risks in the payment of a ransomware. The first mitigation that they stressed is that companies should have a robust risk-based sanctions compliance program, including things like policies and procedures, screening mechanisms, and awareness amongst appropriate audiences within the company of sanctions risks and controls to combat them. Second, it suggests that the company should have a robust risk-based cybersecurity program consistent with the September 2020 ransomware guide issued by CISA. And finally, there's encouragement to disclose to and cooperate with law enforcement. So the idea here is we're going to, OFAC is going to have a much more favorable view of a company that makes a ransomware payment that might inadvertently and unbeknownst to the company involve a sanctioned party, if that's a company that before they ever suffered the ransomware attack was taking steps to address sanctions risks, was taking steps to address cybersecurity risks, and when the ransomware attack happened was open and transparent with the government, made prompt notice, and cooperated with the government. And finally, just a couple of quick trends I wanted to highlight. I made some reference to this before. When you're looking at the people who are out there doing these ransomware attacks, it is an increasingly commoditized business model. They're not just attacking large, sophisticated companies. They're firing shots all over, and they're targeting people in various industries of various sizes, of various sophistication. You're increasingly seeing in the numbers that get reported lower value and higher volume. The average ransomware payment is reportedly tends to be in the few thousands of dollars, around $6,000. And a lot of them we're just not hearing about because it's just happening quietly and people are paying and moving on. Even when these are low value attacks, the impact from downtime is still hugely important. There's also a trend of ransomware for hire, where you've got bad actors out there that are creating the ransomware software and are essentially licensing it to other criminal organizations to use. And you really are starting to see a very sophisticated interlocking series of criminal organizations, which again is part of why the federal government so strongly discourages the payment of ransomware, because it's continuing to fund these organizations. And there are vigorous debates going on at the federal and state level about different legislation to make bans against ransomware payments. What you're typically seeing is consideration of for example, government entities from being allowed to make ransomware payments, so less targeted at the private sector, but still a potential harbinger of things to come, and something that you could potentially see bleeding over into the private sector going forward. So with that, I will turn it over to our last panel.
Thank you, Alex, for the information on potential ransomware payments. Our last presenters today are Louis Grinstein and Andrew Sutherland. Based in our D.C. office, Louis and Andrew are co-chairs of the SEC Enforcement and Litigation Team for the Government Investigations and White-Collar Litigation Department. Each of them have decades of experience in securities regulation and enforcement and have successfully represented corporations, financial institutions, and individuals in a wide range of high-stakes and novel civil and criminal investigations and enforcement actions. Louis and Andrew?
Thank you very much, and thank you everybody for attending and prior presenters for your time. You've now heard from our first presenters about many of the recent developments and strategies in the areas of data privacy and breach responses, SEC reporting, and ransomware payments. Not surprisingly, the SEC's Enforcement Division 2 has been very active in this space, both recently and historically. In a moment, Andrew Sutherland will discuss some of the more noteworthy enforcement actions. As Andrew will explain, the SEC's enforcement activity recently in this space suggests a continuation of the recent trend of an aggressive and ever-expanding enforcement focus on cybersecurity-related issues. Before doing that, however, I wanted to first briefly take a step back to try to set the stage. That is to review how we got here today, so to speak, in terms of SEC enforcement's programmatic approach to cybersecurity-related violations of the federal securities laws. As an initial matter, and as previously noted, the SEC's focus on enforcement of cybersecurity-related violations is not new by any stretch. Indeed, this focus has now spanned several years in different commissions, both the current Gensler Commission and the previous Clayton Commission. To begin with, one of Commissioner Jay Clayton's initiatives was to implement an internal cybersecurity risk profile and create a cybersecurity working group. That working group was designed to coordinate information sharing, risk monitoring, and incident response efforts throughout the SEC as part of the Commission's efforts to address cyber-based threats. As a complement to the Cybersecurity Working Group initiative, in September 2017, the Clayton Commission created a dedicated enforcement cyber unit to focus on targeting cyber-related misconduct, such as market manipulation schemes involving false information spread through electronic and social media, hacking efforts to obtain material non-public information, crypto-related violations such as those involving distributed ledger technology and initial coin offerings, misconduct perpetrated on the dark web, intrusions into retail brokerage accounts, and cyber-related threats to trading platforms and other critical infrastructure. This list of targeted potential misconduct is closely aligned with the SEC's main independent bases for regulating and enforcing cybersecurity issues. First, the SEC's oversight of broker-dealers, investment advisors, and other regulated entities include a number of requirements for those entities' controls around assets and data. For example, there's Rule 30 of Regulation SP, more commonly known as the Safeguards Rule, which requires that those regulated entities safeguard customer personal data. And second, with regard to public companies, the SEC seeks to ensure transparency and full disclosure in the securities marketplace. The Commission thus wields its regulatory and enforcement powers in a manner designed to require issuers to disclose material events relating to their cybersecurity programs and vulnerabilities. The SEC's Enforcement Division's focus was further heightened in February 2018. As Barlow previously covered, the February 21st, 2018 issuance of guidance that updated and reinforced prior guidance by the Division of Corporation Finance, which had provided an overview of disclosure obligations. So I won't repeat what Barlow covered, but I did want to briefly note how the 2018 guidance regarding public companies' disclosure obligations concerning cybersecurity risks and incidents was significant from an enforcement perspective, and not surprisingly, has been followed by several cybersecurity-related enforcement actions. First, the 2018 guidance carries more weight than the 2011 guidance because the 2018 guidance was issued by the Commission itself, not a division. And furthermore, one of the focus of that guidance was on topics frequently at the center of enforcement actions, such as insider trading, disclosure controls and procedures, and compliance with Regulation FD. And as a result of this, as Barlow noted, companies, senior management, and board of directors need to be aware of and take into account this guidance in developing, implementing, managing, and then enhancing policies and procedures, as well as with respect to board oversight of cybersecurity risk and incidents, and setting the proper compliance tone at the top. Not surprisingly, the SEC Enforcement Division, the cyber unit in particular, wasted little time springing into action following this guidance. In April 2018, the cyber unit was involved in bringing a cyber-related enforcement action against a public issuer for allegedly misleading shareholders by not disclosing a data breach in its public filings for nearly 2 years. The issuer paid $35 million in the settlement, which was the first SEC enforcement action against a public company relating to the disclosure of a data breach. According to the SEC, the issuer failed to establish and implement internal controls around the evaluation and disclosure of cyber incidents. They also alleged that the company's senior management and legal staff failed to properly assess the scope, business impact, or legal implications of the breach, including how and where the breach should have been disclosed in its public filings, and whether the breach rendered or would render any statements made by it in its public filings misleading. In this regard, the SEC noted that the company's disclosures in its public filings were misleading to the extent they omitted known trends or uncertainties presented by the breach. And they also alleged that the risk factor disclosures in the company's filings were misleading in that they claimed the company only faced the risk of a potential future data breach without disclosing that a data breach had in fact already occurred. Similarly, in October 2018, the SEC issued additional guidance in the form of a report of investigation, otherwise known as a 21A report, detailing an enforcement investigation into the internal accounting controls of 9 issuers that were the victims of business email compromises, which is a form of cyber fraud. Consistent with the theme in the February guidance in the 21A report, the SEC cautioned issuers that they should consider cyber threats when implementing internal accounting controls. And by issuing the report, the SEC sent a clear message that it expects issuers to not only respond appropriately to incidents, but also to institute effective controls reasonably designed to mitigate the risk of cyber-related threats and to safeguard company assets from those risks. Moving to the current commission, SEC Chair Gary Gensler remains focused on cybersecurity enforcement. In one of his first public speeches following his April 2021 confirmation, Chair Gensler specifically pledged that the Commission would continue to stay abreast of evolving technology and would be ready to bring cyber-related enforcement cases. And then in early June of this year, the Commission announced that it would focus on cybersecurity disclosures made by public companies as part of its regulatory agenda. This is expected to result in new rules on cybersecurity risk disclosures in the near future, but until then, enforcement actions will continue to be instructive, or perhaps most instructive, of how the Commission views cyber-related obligations and its expectations in that regard. Against that backdrop, I'm going to turn things over to Andrew Sutherland, who will discuss several of the more noteworthy enforcement actions, many of which that just came out recently, as well as some key takeaways to best respond to an investigation and steer clear of an enforcement action. Thank you, Andrew.
Yeah, thank you very much, Louis. Thanks to all of our partners here for the great points that they've made thus far in this area. I have just a few minutes here to try to tie in all of these good points and instruction with several recent enforcement actions. I feel like I'm almost at an oral argument here where the red light is flashing that my time is almost up and having to ask the court for permission to proceed in the few minutes that I have, but I will do my best to go through some of this in the last 2 or 3 minutes that we have. So Louis is correct. The SEC for sure is ramping up its enforcement efforts in this space and is bringing a wide range of enforcement actions related to cyber incidents. And these actions are just not concentrated in the public company space, although the cases I'll discuss briefly are in the public company space, but also involve all regulated entities, including financial institutions. With respect to public companies, the focus here really is in several areas. One is, and these were touched on by Louis and by Barlow, corporate disclosures, here including corporate disclosure controls and procedures, whether they ensure timely and, I think really importantly, accurate reporting and filing of information and reports to the Commission. On the accuracy point, the accuracy of public statements and in the required information to be filed with the SEC related to cyber instances is critical because faulty disclosures in this in this area can really trigger not just the internal controls and books and records kinds of charges, but also fraud charges where material misstatements and omissions occur in violation of both the 33 Act and 34 Act anti-fraud provisions. Also, here in the public company area, as I just mentioned, internal controls, internal accounting controls under Section 13 of the 34 Act are a focus. This ties in with Lewis's remarks on the 2018 20A report, where the report cautioned that public companies should carefully consider cyber threats when implementing internal accounting controls and must be sure to calibrate those internal accounting controls to current risk environment and assess and adjust policies and procedures accordingly. So, very important point, I think, to keep in mind when addressing cyber events. The Commission here will really look at the sufficiency of the internal accounting controls, which we know play a very important role in an issuer's risk management approach to cyber-related threats, and also importantly in the protection of investors. Also, the SEC, and I know Barlow touched on this too, will be focused and is focused on codes of ethics and issues involving potential insider trading around cyber events. Information about cybersecurity risks and breaches may be material non-public information. And so the Commission is really examining whether codes of ethics and insider trading policies take this into account to prevent and to detect trading on the basis of material non-public information regarding cybersecurity risks and incidents. And as Lewis noticed, also an SEC area focus in the financial institution space is on safeguarding customer data. For sure, 2021 has been the summer of cyber enforcement. There was a series, the SEC has brought a series of interesting enforcement actions in this space. One set of actions involved 8 registered financial entities. I'm not going to touch on those in the interest of time, but the SEC did bring 2 novel actions against public companies that I thought, or that we thought were noteworthy to flag for our discussion today. The first was in June of 2021, and the SEC instituted an administrative proceeding, which they now can do, related to, an administrative proceeding against the company related to disclosure controls and procedures in connection with cybersecurity vulnerability involving a platform for sharing customer documents. The SEC in this case found that the company failed to maintain disclosure controls and procedures designed to ensure that all relevant information concerning the vulnerability was analyzed for disclosure in the company's publicly filed reports. So in this case, in May of 2019, for context, the company was notified that its document sharing application had a vulnerability exposing over 800 million images concerning sensitive personnel data such as social security numbers and financial information concerning customer transactions. Shortly thereafter, the company went out with a press statement and filed a Form 8K with the Commission. However, and importantly here, at the time of the issuance of the press statement and the Form 8K filing, the company's senior executives responsible for the drafting and filing of those documents were not informed that many months earlier the company already had identified this vulnerability, and the company had failed to remediate the vulnerability in accordance with its policies and procedures. These senior level employees involved with the earlier detection of this vulnerability did not share this information with those responsible for making the public disclosures. And accordingly, those responsible for the company's public statements did not and were not able to evaluate whether or how to disclose the company's prior awareness or actions related to the vulnerability. These corporate execs, again, responsible for actually putting out the public information, lacked certain information to fully evaluate the company's cybersecurity responsiveness and the magnitude of the risk at the time they approved the company's disclosures. The SEC found that the company did not have sufficient disclosure controls and procedures designed to ensure that senior management had all relevant information prior to issuing the company's disclosures about the vulnerability. The SEC ordered the company to cease and desist from violating Exchange Rule 13A, which goes to corporate controls and related to disclosure controls, and pay a civil penalty of approximately $500,000. And then just briefly, also this summer in August of 2021, the SEC instituted an administrative action against an issuer for material misstatements and omissions regarding a cyber intrusion regarding personal data involving student data customer accounts. This case was a little more significant in terms of the charges filed than the June case. Here, the SEC went ahead and charged violations of the anti-fraud provisions, so it was a fraud case. So here, just briefly, some quick facts. And Barlow touched on this exactly a little bit earlier. The company filed a report with the SEC as it was required to do, and its risk factor simply implied that the company faced the hypothetical risk that a data privacy incident could result in a major data privacy or confidentiality breach, but it did not disclose, and that's the key here, that the company had already experienced such a data breach. And later, the company also made material misstatements in a media statement regarding the nature of the breach and its severity. So here, the facts were relatively simple. In March 2019, the company had learned that a sophisticated threat actor had accessed confidential data using an unpatched vulnerability on the data server. And the company also was provided a copy of the stolen data. The company assembled an incident response team and retained a third party to investigate the breach, but determined that it was not necessary to issue a public statement not only at that time, but even after the completion of the investigation, which was a few months later in July 2019. The company at senior level management at the company also met again in July to discuss the incident and again determined not to issue a public statement, but the company did file its required 6K report. It was a foreign issuer with the commission noting in its risks section that a data privacy incident could result in a major data privacy or confidentiality breach, causing damage to customer experience, breach of regulations, and financial loss. The language, and this is where the SEC really focused, implied that no major data privacy breach or confidentiality breach had occurred, when one already had occurred months earlier. And also the company failed to consider, according to the SEC, how certain information about that prior breach should or could have informed the risk disclosure. And then later, in response to a press inquiry about the breach, the company posted the pre-prepared media statement, which the SEC also found to be itself misleading. The SEC found here that these misleading statements, both in the press release and in its filing with the SEC, made material misstatements and contained significant omissions and constituted violations of the anti-fraud provisions of the Securities Act of 1933, and also were found to be schemes to defraud the investing public, also under the 33 Act. The specific provisions the SEC brought this case under did not involve intent, so they did find that the fraud was negligent, but nevertheless significant, and assessed the company civil monetary penalty of $1 million. And also, similar to the prior case earlier in the summer, and as also discussed from the other panelists today, the company found, or the SEC found that the company violated the disclosure controls of provisions under Section 13 of the 34 Act. So I see that I've gone over, and I do apologize. There are a few other things just to touch on. Let me just do it in 30 seconds. But some key takeaways here really would be that every type of business is a potential target of cyber-related fraud. Cybersecurity certainly should be prioritized. As with other compliance and risk efforts, issuers should evaluate cybersecurity risks facing their particular businesses and implement internal controls tailored to address those risks. On the insider trading issue, issuers should really consider whether their insider trading policies are designed to prevent and detect trading on material non-public information related to cybersecurity risks and incidents. And also, in addressing a breach, think about what the work product would look like in the event you need, or the company needs, to present to the SEC. They for sure will be requesting things like policies and procedures, as well as written information concerning security plans and incident response plans. And also, issuers should maintain policies and procedures that ensure all relevant information regarding cybersecurity risks and incidents is collected, processed, and escalated, and evaluated by the right persons on a timely basis, and ensure that issuers prioritize the training of employees on these policies and procedures. And I think the few enforcement cases that I just went through really highlight these kinds of takeaways to keep in mind with respect to cybersecurity. So from here, thank you so much for your time.
Thank you, Lewis and Andrew, and to the entire panel for such great presentations. In closing, as a reminder, if we did not address your questions during the call, we will follow up with you shortly by email. Feel free to contact us directly with any additional questions or comments. On behalf of our presenters and all of us here at McGuireWoods, thank you for joining us today.